And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel this morning are Justice Sullivan, Justice Mary Sullivan, and Justice Sukyoung Shin. We will be the panel for all 5 cases on the hearing list this morning. We begin with our first case, case number 2019 P1567, the Commonwealth versus KEIARA S. Moore. You may begin.
Good morning, Your Honors. May it please the court. My name is Tristan Colangelo from Sugarman, Rogers, Barshak, and Cohen, here representing Ms. KEIARA Moore, the defendant appellant. This case presents 2 issues for the court to consider. One, whether it was error for the Commonwealth to present and solicit Officer Jones's testimony. And second, whether that error, if so, whether that error constituted a prejudicial error or rose to the miscarriage of justice, substantial risk of miscarriage of justice. Officer Jones's testimony was error. It was error for the prosecutor to present Officer Jones's testimony in this case because it indirectly vouched for the complaining witness, Mr. Soriano's credibility, and it suggested that the jury should find Mr. Soriano more credible than Ms. Moore because of the fact that Officer Jones did. First, by testifying that he made a determination to arrest and later charge Ms. Moore after hearing from both herself and Mr. Soriano, Officer Jones indirectly vouched for Mr. Soriano's credibility. The whole totality, the sum and substance of Officer Jones's testimony, it was quite brief, it was very direct, and it simply allowed the prosecutor to inform the jury that both parties had appeared before Officer Jones on the date of question. He and his partner were able to take statements. The same evidence that they had presented to the jury was presented to Officer Jones, and that he made a determination at that time that Ms. Moore was the party that should be arrested and charged with a crime, whereas Mr. Soriano should not be.
Attorney Colangelo, there was no objection to Officer Jones's testimony, correct?
That's right, Your Honor. When Officer Jones's, when he testified, there was no objection when it came in. Now, later on.
So just, I guess, just as a foundational basic, while his answer to the question, who did you arrest, was improper, it's rather obvious, isn't it, that the defendant is the person who was in fact charged?
Yes, the fact that she was the defendant there in the court that day, she was certainly charged with a crime. But
there's really no ambiguity around the fact that that the defendant was the person charged.
No, there's no ambiguity that Ms. Moore was charged with a crime.
I guess one more point I want to tease out a little bit before we continue with your argument, and then you can respond. And I suggest in your reply brief that the prosecutor repeatedly weaponized that testimony. And when I look at the transcript, I see no reference whatsoever to the arrest. I do see a reference to the fact that the defendant was the person charged with a crime, but not having to do with the fact that it was the officer who charged her, simply for the purpose of explaining that the person who is trying to avoid conviction could be held to have a motive to lie.
Right, I guess I can answer that in a couple different ways. And yes, I do think it's important when you're evaluating this case on a standard of review that there was an objection made at closing argument for the use of the testimony of Officer Jones's testimony.
But again, I understand that the objection was not made for the use of the officer's testimony because the argument didn't tie that to the officer's testimony. It was the fact, again, that you have someone who is a criminal defendant would have a motive to lie in order to avoid conviction stands whether Officer Jones had given any testimony or not, and the prosecutor's argument did not refer to the officer's testimony in relation to that portion of the argument.
Well, I believe it
was improperly overruled.
I believe that the prosecutor's closing actually did refer to and request that the jury look at everyone who testified. And from the Commonwealth's perspective, there's only two witnesses who testified. It was the complaining witness and Officer Jones. This was put to the jury as a credibility case. The prosecutor couldn't have been more clear about this. You can either choose to believe Mr. Soriano or choose to believe Ms. Moore, but you can't have it both ways. Their testimony was just so at odds with each other that you couldn't possibly believe both of them. So when the prosecutor is referring to look at all the witnesses who testified, look at the testimony as elicited by the Commonwealth, you're including in there the fact that Officer Jones had heard the same testimony because when Ms. Moore took the stand, the Commonwealth made sure to clarify that everything that she was testifying to in court that day had also been presented to Officer Jones on the date of the incident. So everything that had been presented.
I think you also pointed out that the opening statement referred to Officer Jones's testimony, who, quote, was involved in the situation and who dealt with the situation and interacted with the parties involved. That was the opening. And then the closing, the jury were asked to, quote, think about who's here charged with the crime. And this followed on his statement that there was an arrest. So my understanding of your argument is that we should look at all three things.
That's right, Your Honor. You are. It's the use of Officer Jones's testimony in opening, in the direct, as well as in closing. And I think the concerns that Justice Green was referring to in the closing, while the word arrest may not have appeared in the same sentence as Officer Jones, the concern is that as a criminal defendant, Ms. Moore has a presumption of innocence. And the Commonwealth cannot use and intrude into that presumption by suggesting that the mere fact that she was charged with a crime is some sort of evidence of her committing the crime. And to chip away at that by saying she's not necessarily a credible witness because she has a motive to lie because she's a criminal defendant, well, that would apply to every single criminal defendant ever.
Well, it might, and it might be a proper argument in another case. The question is whether the confluence of the three factors makes this a different case from other cases where we have said that similar errors in closing or similar errors in the admission of testimony aren't substantial risk. I think that's the question we have to face. I mean, we've seen cases with testimony like this where under other circumstances, we have found there to be no substantial risk of a miscarriage of justice. So what do you think your best case is for the confluence of factors that you are arguing here?
I think if you look at Commonwealth v. Bjor, which was an appeals court case that I cited in my brief, the facts are stunningly similar. There was a physical altercation. Both parties sought a criminal complaint out of the district court. They went before a clerk magistrate. The clerk magistrate held that there was probable cause for the alleged victim, the complaining witness, to go forward, but there was not probable cause for the defendant. So later on in the criminal trial, the Commonwealth presents evidence that the defendant had sought a criminal complaint, but the clerk magistrate had found that there was not sufficient evidence to move forward with that. As I said, at issue, there was a physical altercation. The defendant was claiming self-defense. The evidence related to the principal issue at trial, which was who was more credible or not. There was really only the two witnesses. The clerk magistrate's rulings came in, and the appeals court determined that it carried the imprimatur of in that case, it would have been a judicial imprimatur by the clerk magistrate.
I was going to ask you whether or not the fact that that's a judicial imprimatur case matters, or whether, I believe you also cited Stuckich in your brief, whether police imprimatur carries the same gravitas as judicial imprimatur for purposes of substantial risk.
In this case, I think it does, and I think the analogy to Bjorn is a solid one for this reason, is that the officer was essentially put in the same position as the clerk magistrate was in that case. He had both witnesses in front of him. He got the testimony directly from them. He could see them, he could evaluate them, and that's essentially what he did. And he took the same steps by arresting and then charging Miss Moore, but not Mr. Soriano. So there is a distinction. I tried to make that clear in the brief, and there is the official versus judicial aspect to it. But I think in this scenario, the Officer Jones was actually in the same position as the clerk magistrate was in Bjorn.
Let me circle back just for a moment, just because I want to clarify something that an exchange that you had at the very beginning of Judge Sullivan's questions, and that is that if Officer Jones had not testified, and the prosecutor had pointed to the fact that the defendant in this criminal case would, by virtue of their interest in avoiding conviction, have a motive to lie, in your view, would that be improper argument?
If that was the sole basis for it, I think that's starting to intrude on the presumption of innocence. Yes, I don't think that alone.
You have a case to support that suggestion?
I would have to review my brief. I remember I was looking into that, but I don't have one off the top of my head. Because
I mean, the motive to lie is typical impeachment, and the fact that it's not routine for criminal defendants to take the stand, but once they do, they can be impeached by the fact that they have an incentive to avoid conviction, right?
Yeah. I mean, I see what you're saying, but it's the same reason that the judicial process can't be used against criminal defendants. In other words, the fact that there's an indictment that's been issued in the case can't be used as evidence of the defendant's guilt. Now, the fact that there's an indictment,
it's not affirmative evidence, but it is impeachment. And I had understood from your brief that your argument was a narrower one, that the officer's assessment on the day that both of the parties appeared before him, the officer's assessment of their conflicting accounts and determination to charge one and not the other implicitly endorsed a particular view of the credibility and of the evidence, and that the prosecutor should not have been allowed to bring that before the jury.
I don't want to stray away from my argument. That is the central plank of the argument. Absolutely, is that that's the vouching for Mr. Soriano's credibility, is that inherently Officer Jones chose to believe Mr. Soriano, not Miss Moore, and that is why Miss Moore was charged and Mr. Soriano was not.
All right, we have lost our clock, which means we've also lost our clerk. I think we'll have to. Well, you had about a minute and a half left. How much more do you have to tell us? And once we go back after this argument, we'll return to the waiting room, and I'll time this next argument. Go ahead, Mr. Colangelo.
I can wrap things up. I
actually had a question for you, Attorney Colangelo. Going back to Bjorn, isn't there a distinction there? Because in Bjorn, had the information not come in improperly, the jury would not have known that the defendant had filed a complaint and it was not allowed to go forward. Whereas here, as Chief Justice Green pointed out earlier, it would have been evident to the jury whether or not the officer testified that she had in fact been charged. Isn't that a distinction?
In one sense, yes, but there here there wouldn't have been. I guess the what I'm trying to say is nothing would have suggested that Mr. Soriano wouldn't have also faced some sort of criminal charges out of this incident as well. And by testifying in the manner that he did, Officer Jones made it clear that he did not arrest Mr. Soriano. And then the prosecutor took it a step further to point the finger at Ms. Moore throughout closing that there was only one person on trial. There was only one person charged with a crime. So, you know, domestic disputes can happen all the time where there are cross complaints and there are, charges made against both. That was taken off the table here.
Okay.
All right. I think we'll leave it there. Student Attorney Zarella, you may proceed.
Thank you, Your Honor. Good morning. May it please the court. Ariana Zarella, arguing with leave of the court. With me is ADA Houston Armstrong, and I would also acknowledge trial prosecutor Madeline Stern. This court should affirm the defendant's conviction for assault and battery against a household member. The Commonwealth is conceding that the prosecutor's question and Officer Jones's answer is error. However, the isolated and unobjected to incident did not result in a substantial risk of a miscarriage of justice for 3 reasons. The first is that the Commonwealth's case is strong. This case pointed powerfully towards the defendant's guilt through the evidence. The jury heard testimony from both the defendant and the victim, and they could physically assess the demeanor of each party as they testified. Furthermore, the jury was presented with photographic evidence of both the victim and the defendant, which allowed them to physically assess their version of events. The jury chose to credit the victim's version of events over that of the defendant because most likely the defendant's version of events does not account for her lack of injuries and the extent of the victim's injuries. The second reason being that the error was an isolated incident that was never referenced to again by the Commonwealth.
If I could stop you there for a minute. Obviously, this is a credibility call for the jury. But how is it that the evidence that you've just referenced tells the jury who was the first aggressor and who was engaging in self-defense, which is probably at the core of both the charging decision and the jury verdict?
Yes, Your Honor. So I believe that in this situation, the defendant is testifying that she was not the aggressor and that she was acting in self-defense, but the photographic evidence showed that if she had been choked like she said she was, that was not apparent in the photographic evidence. And the defendant's photographic evidence of him having a black eye, of him having bruises on his neck, that indicates that it was not, that his injuries were more severe than hers, and therefore she could not, her version of events just couldn't possibly be true in that situation.
That's where I'm having a hard time following you. I mean, I don't know that the jury needs to believe that choke marks being choked always leaves a mark, but how does the severity of the injury equate to who was the first aggressor?
Because the severity of the victim's injuries, the severity of the victim's injuries was much more severe that it shows a physical presentation of what happened. That his injuries were so extensive that she clearly had attacked him. She tried to choke him with his chain. He had a broken chain that was also in the photographs. That's also in the record.
She acknowledged there was some sort of scuffle. I don't see how the severity of his injuries is necessarily inconsistent with the claim of self-defense.
She never actually admitted to hitting the defendant, but he had a black eye, which means that she must have.
But she said that, he was the first aggressor and then they had an altercation. She might not have said directly that she hit him in the eye, but it seems to me to be consistent with her story. There's nothing inconsistent, in other words.
That could be true, Your Honor. I just believe that if she had been more forthcoming with the truth, then possibly the jury may have sided with her. But I think that because she didn't, that is why the jury chose to look at the photographs and make their decision. They also could see the demeanor of each party as they testified.
So is the Commonwealth conceding only that it was error to ask the question about the arrest, or is the Commonwealth conceding that it was error to put the officer on the stand at all?
The Commonwealth is conceding only that the prosecutor's question and the officer's answer is error.
So what was the purpose of putting the officer on the stand then?
So the officer quite honestly does not add much to the case, but he does corroborate both the parties' stories that they went to the police station, and because he makes a fact more or less probable, that makes his testimony relevant. The Commonwealth just wanted to provide the jury a chronological event that led the defendant to be before them in front of the jury in court.
But that was already provided by the parties. I mean, there's no dispute about the timeline. So what did the officer's testimony add other than to maybe to prop up the victim's version of the story?
I think the officer's testimony in this case specifically was just part of the story. He did not add too much, but he did provide that corroboration component. You are correct, Your Honor, and I think he did not add too much, but he did provide that, and the Commonwealth is just trying to be chronological and explain to the jury certain how the defendant got there.
Okay.
How is that relevant?
So the Massachusetts Guide to Evidence, Section 103, is a very low standard for relevant evidence, just that the evidence has to make a fact more or less probable. And in this case, the fact that he was able to corroborate the fact that both parties went to the police station, more or less probable, in this case, more probable, that makes the evidence relevant.
Not the question or the answer. You would agree
just,
that the question and the answer were not relevant.
They were in error.
Because they're not relevant or for some other reason?
Because it is improper for the prosecutor to reference the defendant's arrest.
But for evidence of external corroboration, I mean, he didn't present corroborating evidence. His testimony, to the extent it tended to corroborate an account, was really implicit based on his evaluation of the competing accounts, and that, of course, is a form of vouching.
I don't believe that vouching occurred in this case because the officer never specifically testified to an opinion. He simply stated that the parties came and that they spoke with him. The prosecutor's question as to whether one of the parties had been arrested afterwards wasn't proper.
But it's hard for me to separate the force of an implicit vouching from the answer that you gave to the relevance of the testimony. Simply because something is relevant doesn't make it proper.
Right.
If the relevance of his testimony was that it tended to corroborate the victim's account or the non-charged party's account of the altercation, based on his assessment of their competing accounts, that may be relevant, but it's also improper.
You would be correct, Your Honor. I think in this case, the Commonwealth was simply just trying to corroborate both the parties' version of events, that they went to the police station. It was just about chronology. They were just trying to paint the whole story for the jury. However, the error was an isolated incident that was never referenced again by the Commonwealth. The prosecutor did not reference Officer Jones's testimony in her closing argument. And furthermore, the judge's instructions to the jury further diminished, if not eliminated entirely, any prejudicial impact that Officer Jones' isolated answer.
What do you do with the fact that the prosecutor specifically directed the jurors to pay close attention to the officer's testimony in her opening, and then makes the statement in her closing regarding assessing credibility based on who has been charged, shortly after the officer testified that he made the decision to arrest only one party in the case? How do we assess that?
I think you would assess that the closing argument in this case was actually proper because she marshaled the strong evidence against the defendant. And because the prosecutor did not reference Officer Jones's testimony, there was no improper.
Well, but she all but did. She said, look at who's charged. Shortly after he's testified, I decided to charge him and not her.
Well, he did not specifically testify that. He didn't testify to any opinions or give any conclusions of law.
Well, the question is, who did you arrest? After speaking about this, did you decide, did you and your partner arrest one of them? Yes. Who did you arrest? Mrs. Moore. have to come right out and say it, does he? Aren't we always saying that jurors can make logical inferences?
They can, yes. However, in this case, the judge's instructions would have allayed any prejudice from that. He specifically reminded the jury of the defendant's presumption of innocence, and the fact that she was before them in court they should not read anything into that, basically. So he specifically instructed them on the presumption of innocence, and he specifically instructed them that they can only assess the evidence, and he also specifically reminded the jury that prosecutors' questions are not evidence, only the answers are evidence.
Okay, but in the closing, she also said the defendant told the police everything she just told you on the stand, and yet she's the only person on trial. So what is the jury supposed to take from that? I mean, isn't the implication there that the officer didn't believe her?
Yes, but I think that the jury looked at mostly the photographic evidence in this case and the physical demeanor of the parties as they testified.
Well, how do we know that? I mean, presumably the officer was a good witness, or the Commonwealth wouldn't have put him on the stand. So how do we know that that didn't affect the verdict, especially when the Commonwealth used it in closing? I mean, she might not have expressly referred to his testimony, but it seems to me that's the natural implication of the argument.
Well, so the jury knew that it was very apparent from Officer Jones's testimony that he did not witness the event. So he was solely the third party that the parties came to. So I don't believe that the jury would have seen his testimony.
But just like the jury, he heard both sides of the story, and the Commonwealth elicits from the defendant that her testimony was exactly the same story she had told the officer, and yet the officer chose only to arrest her. So how is that not prejudicial?
I think because the fact that the jury also, again, had the photographic evidence and could see the demeanor, I think that, I mean, there's no way to really know what a jury is thinking, but the evidence was so strong in this case, and they were able to see the physical demeanor, which we're not able to see now. I think that those are two strong points against
if we don't share your view that we can rely on the severity of the relative injuries that the two protagonists suffered, we cannot determine from the severity of the injuries who it was that was acting in self-defense and who it was that was the first aggressor. What does that do to your argument about the strength of the evidence?
I think it goes back to credibility. The reason that this case is all about credibility and the fact that the victim's photographs are more telling of his version of events. They line up with his version of events, whereas the defendant's version of events just doesn't line up. And when a case is about credibility and the jury is looking at that.
Okay, well, I'm at a little bit of a disadvantage because I don't think we have the photographs in our record. And I think beyond that, you say that, but it's not clear to me. I think I need to have you sort of connect the dots a little bit more specifically rather than just offer that characterization before I'm persuaded that what you're saying holds force. What about the pictures? What is depicted in the pictures that establishes a greater alignment with the victims than the defendant's description?
Specifically that the victim is claiming that he was choked and he has bruises on his neck. The victim is claiming that she was choked and she only has minor scratches on her neck. The fact that the victim does have the black eye, the fact that the victim claims specifically that the defendant choked him with his own chain and the chain broke, and we have photographic evidence of the broken chain. It just lines up more with the victim's version of events than the defendant's version, specifically in that way.
Did the defendant address any of those points? I mean, did she deny that the chain broke?
She did not deny it, but she did not specifically state that she had hit him, which would have resulted in the black eye, and she didn't mention breaking his chain at all. She didn't mention his chain in her testimony. So if there are no further questions.
In the minute you have remaining, I wanted to give you the same opportunity to tell us what case you think best supports your argument that there's no substantial risk here, assuming, of course, we've got the complication that the closing is objected to. So So we have both a prejudicial error and a substantial risk analysis operating in this case. But let's take the substantial risk standard. What's your best case?
The Commonwealth's best case is Matos, the Commonwealth v. Matos, which is cited in my brief at page 16. Chief Justice Green was also on that panel. It was a recent case, and the court found that there was not a substantial risk of a miscarriage of justice in that case because the officer specifically did not testify any opinion that the defendant committed the crime or give any conclusions of law. And in this case, Officer Jones did not do that as well. And so I believe that that would be the Commonwealth's best case.
Okay.
And if there are no further questions, then the Commonwealth may rest on its brief.
Thank you. Thank you both.
Thank you.
Thank you, Your Honors.
We are live and on the record.
All right, our next case on the list for hearing this morning is case number 2019 P 1065, the Commonwealth versus Elliot N. Davis. You may proceed.
Good morning. May it please the court, my name is Andrew Smith and I represent Mr. Davis. Today I'm asking this court to overturn Mr. Davis's convictions and return his case to the trial list in Fitchburg District Court, or for a finding of not guilty. My sense here is the facts are relatively straightforward, so I'll keep my comments relatively brief. If I may say so, I agree with defense counsel's closing when defense counsel noted that this is one of the least excited 911 calls she had run across. I worked for years out of Hampden County, and I agree. The complainant is calling with a neighbor present. The neighbor has been present for a while. The incident happened a while ago, and she's not calling for and in fact refuses medical treatment. We have very little sense when the incident did occur, though we know he's left the apartment. Equally important, the complainant is calling to request police intervention, not for the incident that occurred, but she's concerned he'll be angry and return later.
Well, doesn't that expression of fear derive directly from the attack that she is also calling to report?
It would be based on the incident she called to report, yes.
And her fear,
still under the influence of the incident,
right,
is
right. But her fear, even though she may reflect a cool and calm demeanor, her fear, in fact, is an element that we ought to take into account in assessing whether she's still under the grip of the event and making her report in response to that.
certainly, but she may very well be in fear 2 days later. I mean, that fear may not subside.
There are a variety of different factors that
course.
we're not talking about 2 days later. We're talking a very brief time later, where she went to, the reason she was in the presence of her neighbor was because, according to her, the defendant had taken her cell phone and disabled the phone in the house. The evidence is not precisely clear on the nature of the devices, but the point is that she was unable to call because of the defendant's actions, and so she went to a neighbor in order to make that call. She did so promptly, and she did so out of fear that he would return and attack her again.
Return at some later point, yes.
Yeah,
I think she says at night.
So the Commonwealth, in its brief, cites Commonwealth versus Wilson. You're familiar with that case. You don't address it in your brief, but how do you take the circumstances of this case and compare them to those in Wilson, and suggest to us that the judge abused discretion in admitting this evidence?
In Wilson, there was a sense that the she was still under the influence of the exciting event.
Based on what?
She didn't appear frantic or excited, but she was under the influence of the event.
Because of what?
Because it was a medical emergency.
Right. So that I guess my question to you once again is her expressed fear that the defendant was going to come back and kill her, and she was seeking police intervention to protect her against that threat. How is that different?
It's certainly a factor the court considers, a factor we considered. But it is a forward-looking concern.
She says, and again,
I think interestingly,
I have questions for both of you on the record. There was no Rule 8 reconstruction here. I take it that you do not disagree with the Commonwealth's representation that the 911 tape included her statement that he just left.
I have no position on that. It's not part of the record right now. Unless I'm mistaken.
For that matter, the only transcription that we have of the audio tape comes from the motion in limine and not from the trial.
That's correct.
Were there portions of the recording that were redacted or not played for the jury?
It's my understanding, no, it was played
in its entirety.
That's my understanding.
So that the transcription from the motion in limine or would be identical in all respects to the portion in the trial where it says audio played for jury or whatever it was.
That's my assumption, yes.
Okay, but for the fact that we have one missing piece that the Commonwealth represents includes the statement he just left.
Yes, and I'm certain. I'm hesitant. I'm certainly not going to accept that as what can be heard in the recording. And the Commonwealth doesn't.
We don't have the recording itself. We have requested it from the trial court. We will have to sort that out, I suppose. We do have, even in the absence of a Rule 8 action in the trial court, we have the ability to correct the record on request of the parties. So we'll have to listen to the tape and see what it says. But I guess I would, for future reference, encourage you in these circumstances to complete the record before you come to us rather than asking us to do so afterwards.
And Your Honor, I do apologize. It's I trust my transcriptionist to vigorously track down stuff that can't be heard. So her work on this, I accepted as the best she could do.
Well, quite apart from what the transcriptionist could do, there is a mechanism under Rule 8 to go back to the trial judge or have the parties reach some kind of an agreement if they can. If they can't reach an agreement, then they submit the question to the trial judge. That's a rather significant element of the case, and it leaves us a little bit betwixt and between in trying to sort out the legal issues of the case.
Well, relating to the nature of the 911 call, he just left doesn't really reflect at all on when the incident occurred. She says it occurred a while ago. So even if we accept the Commonwealth's representation, this only goes to when he left the apartment. The fight could have been an hour before.
I thought her words were a little while ago.
A little while ago. And then she says...
It seems to me that if she was attacked, and then shortly after, I don't want to put too many characterizations in it, but immediately after he just left, she goes to find someone who can allow her to make a phone call to report the incident because she is afraid that he's going to come back and kill her. Then the period while he remained in the apartment even if it was 5-10 minutes, would have been a period where she was afraid of him. Right?
We're assuming it was recent, but sure, certainly.
She said a little while ago.
A little while ago, and then the neighbor was, has been with her for a while, I think. But again, this is colloquial.
I understand.
A little while, I mean, there's no number put to it. There's no sense of 15 minutes, 6 minutes. Certainly from the call, there's no crying. There's no cracking of voice.
Wilson
There's
makes
no
clear
sobbing.
that is not an essential element of an excited utterance, depending on the circumstances.
No, but like fear, it's a factor. So certainly if fear is present, that would be a factor toward excited.
Correct. And
there are any number of factors that conspire against excited.
On fear, we do have her expression of fear that he was going to come back and kill her. That's a rather significant fear, is it not?
Oh, it's a very significant fear. Would it diminish in a day? I mean, the fear is certainly a factor, but, oh, I'm sorry.
What's our standard of review? Is it abuse of discretion or is it something
Yes.
else? All right. So
I believe
you make, the points you make are interesting and could have permitted the judge to make a different kind of ruling. But where in the mix do we reach an abuse of discretion?
I certainly am concerned, having been through these in person. The judge doesn't seem to go through the analysis in making the decision to let in the 911 call. I was counsel on Rodriguez, which is cited in the Commonwealth's brief. And that's another instance where it's almost as though 911 calls in practice are being allowed to be entered with only minimal. I mean, there's argument, but there seems to be minimal analysis by the judge as far as allowing it in.
Well, it's hard to tell. It's hard to tell how much analysis or deliberation the judge conducted without articulating it verbally on the record, right?
It's difficult, yes.
And that is true, frankly, in virtually any evidentiary ruling that the judge makes during the course of a trial. An experienced trial judge will in most instances, run through a mental checklist of the various factors that they are to apply and then issue a ruling. This is a little different in the sense that it was on a motion in limine. It's not in the midst of trial, but it's not the norm for a judge to offer a detailed rendition of this precise analysis that they went through in making the ruling.
No, but certainly I would feel more comfortable if the judge at least used the language of the case law and said, I find it's an excited utterance and I find it's not testimonial.
I mean, that's the
appears to
standard. I mean, to me, that part almost goes without saying. To the part that would be more helpful would be explaining why. But again, we have all of the factors that bear on that, and it's up to us to evaluate whether a decision that this was an excited utterance was within the range of reasonable alternatives, right?
That's correct. And again, this is a district court case, so things are moving fast, and
right.
This is a kind of a high velocity environment, and I've certainly been in front of judges to make decisions like this as well. But it is difficult, especially with an issue this potentially complex. it would certainly be somewhat reassuring to hear the language of the standard, if not some explanation why, especially with very significant argument on both sides leading up to the decision.
You have 56 seconds left. Do you want to continue on this or address your other argument?
Thank you. I actually can't see the time, so thank you for telling me. I'm not seeing time right now.
40 seconds left.
Thank you. I would just remind the court regarding the testimonial issue, we're certainly weak on the per se testimonial, but the idea that a reasonable person in Clarence position would anticipate statements being used against accused in investigating and prosecuting a crime, that's language from Gonsalves. That standard certainly seems to be met as far as the nature of her 911 call, leaving aside the excited utterance issue.
All right, thank you.
Thank you.
For the Commonwealth?
Good morning, Your Honors. Nathaniel Bodwin for the Commonwealth. I would, in terms of the first issue with the 911 call, I'm arguing that the judge properly exercised his discretion to allow the call in. And it certainly came out during the previous argument that I do rely heavily on the Wilson case for the reasons that this victim was in the same location where the event occurred, that the judge heard the 911 call during the motion in limine hearing. He specifically stated before in terms of whether, the question is as to what he heard, he stated before they played it, I'm going to stand up to make sure I hear this tape very clearly. So again, I believe he would have heard her say that the defendant had just left.
Well, once again, you're relying on that, and you rely on that element heavily in making your argument, and yet that is not our record.
Yes, Your Honor. And to that point, I would say that it was admittedly, I was able to obtain this from the Fitchburg District Court as well as the other exhibits. Due to the pandemic, that was a little bit challenging to do, but I did get that. I apologize for not moving to get it on the record prior to the argument. And I believe, Mr. Chief Justice, you mentioned the court was going to order that.
Well, we would like to get it. So are you telling me that the actual trial exhibits are in your physical possession and no longer in the possession of the clerk's office?
I have copies, Your Honor.
Copies. Okay. Let me just ask, I guess, it's difficult to, in part because of the pandemic, to get the best response from the clerk's office. I would ask if you have copies and you and Mr. Smith can get together and agree that they are copies suitable for our use. I would ask you to submit those to our clerk's office as soon as possible. We have reached out to the clerk's office, but it's unclear when we will get those.
I'd be glad to work with Attorney Smith to do that.
But that was only one part of my concern here, or my lament. Just getting us those exhibits without having filled out the record under Rule 8, there's a procedure for this. And it's not our typical role to resolve questions about the record. That should be resolved before the case comes to us.
Certainly understand that, Your Honor. I know it's the defendant's burden to provide the records, but I certainly understand the Commonwealth's role in that as well.
Well, I mean, it's the defendant's burden, but to the extent that you are relying on a portion of the record that is not a portion of the record, it seems to me that you bear some responsibility as well.
And I accept that responsibility, Your Honor. In terms of, I don't want, if there's any further questions about the 911 call, again, for the reasons that were stated in the brief, I do believe it was an excited utterance. I do not believe the call was testimonial. I don't know if your honors have any questions specifically about the call, or I can address the strangulation issue if you have any questions on that. And I can go right to the strangulation aspect. I believe the evidence that was before the jury was that this defendant choked the victim in such an intense way that it left red markings on her neck. And I think that evidence was reasonable for the jury to infer that her breathing was hindered somewhat during that choking. And no, it was not direct evidence, but it was circumstantial evidence. And your honor, and that circumstantial evidence doesn't have to require a guilty finding. It only needs to permit a guilty finding. So I would suggest that.
I'm sorry, go ahead, Judge Sullivan.
Go right ahead, your honor.
We don't have the photos either. But you're asking us to hold that the presence of red marks on someone's neck necessarily means, or not necessarily, but you can imply that her ability to breathe was hindered. I mean, isn't that speculative?
I do think it's a reasonable inference, your honor. Not only did they have that photo, they had the testimony from the officer as to his observations of the victim, that he saw redness around her neck. And also he confirmed that the photograph that was introduced as evidence was a fair and accurate representation of how the victim occurred, how the victim looked at that time. So you have the...
I mean, depending on how the hands are placed, can't there be a situation where one could leave red marks on someone's neck but not interfere with their breathing? The hands are on the side of the neck. I mean, it just seems to me to be very speculative to infer that red marks means she couldn't breathe.
So according to the statute, your honor, strangulation, yes, is an interference of normal breathing. And we had the victim, the jury heard the victim in the 911 call refer to it as that the defendant choked her. And I referenced, I believe, the Rogers case that gives a definition of choking, which is to hinder breathing. And
so
I think
her use of the word choke gets you over the hurdle. Is that what you're arguing?
I'm saying all that evidence together, her use of the word choke, the introduction of the picture that it did display some redness on her neck, the officer's observations, all of that, I think, was reasonable for the jury to infer that since this defendant choked her in such a violent manner that it would have left redness on her neck, it was reasonable to infer that during that choking, her breathing was hindered. And I think that was circumstantial evidence, and it was a reasonable inference.
What is the act that supports the conviction for assault and battery?
Hold on. The assault and battery on a family or household member.
Right. What is the act that supports that conviction? Isn't it the same act?
Well, this was not, wasn't raised as an issue on appeal, and I did not look into the issue, but if your honor, off the top of my head, I can't describe to you all the different elements between those crimes right now. If you'd like a follow-up letter, I can certainly address that.
No, I was just wondering if I had missed something in the record, because it seems to me that the convictions as to the wife were based on the 911 call, and I wasn't able to decipher more than one act from that 911 call.
Right. So yeah. So the three charges with yes, I understand your question, Your Honor, and I can't go into any more detail than that.
Sure. Okay. Thank you.
And if there are no further questions, Your Honors, I'd be glad to rest on my brief.
Seeing none, thank you both. The case is
Thank you.
We are live and on the record.
Thank you. Our next case on for hearing this morning is case number 2020-P436. This is a case involving the termination of parental rights. I'll remind counsel that the case is impounded. Please refrain from referring to any of the names. Refer to the individuals involved in the case by reference to their role in the case: father, child, mother, etc. With that, Healy, you may begin.
Thank you, Your Honor. Your Honors, may it please the court, my name is Julia Healy and I represent the appellant father in this case. Your Honor, my client provided very good care of his children in the over 6 years that he was with them. Youth sports, trips, the children were constantly asking for him. After about 5 years, he did move out of the home and file for divorce from his wife. He continued to see the children and care for the children at the same level that he had when he lived with them. In the 8 months before his wife's tragic death, DCF was aware that his wife suffered from mental health issues because my client told them. My client started calling in June of 16 and telling DCF that he was worried about her condition, that he didn't know who she was anymore. Rather than abandon his family, he stayed with them through that time, moving with them to Maine when mother moved to Maine, and then moving them to his mother's house for the month before she died. He did this, and the uncontested evidence is clear, he did this because he was concerned for her mental health. He wanted to remain being a father to his family. In the month before her death, DCF, in addition to hearing from my client, also heard from the wife's sister, that she believed mother needed hospitalization due to a possible breakdown. DCF then talked to mother, told mother that she needed treatment. Mother agreed to go to the hospital and get treatment. However, she did not go. DCF did not share any of this information with my client or at any point ask my client to obtain help for his wife. 6 weeks before she died, as I said, DCF knew that she had a serious mental health condition, that she was in trauma, that she was not getting the treatment they asked of her. They could not locate her, yet they continued to tell mother and the police that they had no protective concerns. And in fact, they planned to dismiss the case. They sent mother a certified letter saying they were going to dismiss the case. They simply had no concerns about this family.
If I may stop you for a moment, I think everyone can agree that what happened with this mother is terribly tragic.
Yes, ma'am.
Events of this sort are very difficult to sort out, and people spend a lifetime afterwards thinking through what happened and why. But today we're focused on father, not on mother.
Yes, Your Honor.
And so I'd like, if I could, to just walk through a couple of evidentiary or procedural issues with you so that I can place your argument in proper context for myself. First of all, you have made a hearing that you think that he was deprived of fair consideration at the 72-hour hearing under Walt. But as I look at the docket, page 8 of the record appendix, the emergency removal occurred on March 27th, and the 72-hour hearing was promptly scheduled, but then was rescheduled twice and heard on April 26th. And counsel had been appointed at that point. We don't have a transcript of that hearing as it was ultimately held. How are we to review this issue, and was not the 72-hour hearing waived?
Your Honor, thank you for your question. I am not objecting to the 72-hour hearing, we are not appealing the 72-hour hearing. The reason I briefed reasonable efforts is because it is important for the court to know that DCF simply used no reasonable efforts to avoid removal. It is part of my—
But how do we know that if we have no record of what occurred when the 72-hour hearing was heard 27 days later? I appreciate your argument can be made from that point forward based on the evidence that we have, but we have no evidence as to what occurred in those 30 days, do we? Or of what the judge's basis for decision was at that time.
When you say 30 days, Your Honor, are you saying we have no evidence as to what happened from when mother entered the hospital to the 72?
I'm talking about between the emergency removal and the hearing on April 27th.
And my argument,
what was presented at that hearing.
that's correct, Your Honor. My argument goes to before the emergency removal. DCF has an obligation to use reasonable efforts to avoid removal. And there is evidence in the record that they decided to remove this child solely based on my client's appearance at the hospital, and that they decided to remove the child before they even spoke to my client. When they went to my client's house, they did it to remove the child, not to make it.
But we don't know that because we don't know what happened at the hearing on April 27th. We don't know if there was other evidence presented to the judge.
Your Honor, the trial court found that the removal was done because of my client's appearance at the hospital.
That's different.
That was a finding, I believe it's 171, Your Honor.
Yes,
that is
okay.
a finding. And Your Honor, I believe it's in the in the exhibits, and I'm happy to get Your Honor cite if you would like it, but it is clear in DCF's own records, they say, we met with the APM and other people up in DCF, and we decided to remove the child, and then we went to father's house to do the removal. So there is clear evidence that they decided to do it based on.
Counsel, how can you challenge that decision now after there's been a full trial now on the CNP?
I'm not challenging that decision, Your Honor.
Oh, okay.
That wasn't clear in my brief. I very much apologize. We are not appealing the 72. My argument.
So then what's the relevance of the argument?
The relevance of the argument, thank you, Your Honor, is that there was no evidence that my client was ever an unfit father. So sometimes, people will say, well, there was evidence at the removal that there was an allegation of abuse or neglect, or this happened at the removal, and that's evidence of unfitness. That never happened here.
Okay, but if there's enough evidence of unfitness after the emergency removal, then why does that matter?
It wouldn't matter if there was evidence of unfitness after the removal, but there wasn't.
What we've got, as I understand the considerations that animated the judge's ultimate conclusion on unfitness and termination, there were substantial unresolved issues of substance abuse for the father, and a long history of criminal conduct, including violent felonies.
With all due respect, Your Honor, neither of those are true. DCF painted this with a very broad brush and said, oh my goodness, father had been in jail earlier on in the case. Father admitted that he smoked marijuana. That is not, Your Honor. If you look at it, the judge, with respect to, I'll start with the criminal history, if I may. Criminal convictions are only relevant to the extent they bear on parental fitness. In this case, father had not had a conviction other than what happened at the DCF office. No conviction since 1997. That's 21 years before trial. He had not.
If I may, counsel, with respect to his criminal record, this case was tried after George and before adoption of Luke, but I don't think the law changed that much between the two. All of the police reports were admitted by stipulation. I think that appears on pages 26 to 30 of the transcript on day one. Once those police reports come in, was the judge permitted to consider the cases that did not result in conviction and to rely on the facts asserted in the police reports? Certainly the department and the counsel for the children have relied on those heavily. I didn't see an argument challenging that, and I wouldn't expect to see one given the stipulation, but what do you say today is the proper use of those police reports?
I don't believe the stipulation changes the law, Your Honor. Adoption of Frank is clear. The police reports can only be relied upon if they contain personal knowledge. There were 3 open cases at trial. 2 of those police reports contain no personal knowledge. The author, the police officer author, did not have any personal knowledge of what he was writing. There was one, and there were the police officer what did have personal knowledge. He also testified at trial to personal knowledge, so he clearly did have personal knowledge. Personal knowledge that he had was my client making a flippant, stupid statement. I don't stab tires, I stab people. But he did not.
Why does the stipulation not alter the equation?
Allowing something to be admitted as evidence doesn't mean the court can use it in a way that this court and the SJC has says they can't use it. Allowing a witness.
There was no limitation. It says stipulated so that we don't have to produce live witnesses.
But adoption, Your Honor, adoption of Frank is a limitation. Allowing a witness to testify doesn't mean they can testify to hearsay. Allowing somebody
But if they do testify to hearsay without objection, then it's before the court. And more importantly, if you stipulate, it's perfectly permissible and in my experience, somewhat routine for parties to, for convenience, to stipulate evidence into the record that otherwise would be hearsay. If you're going to impose a condition or limitation on the submission of that material, then it's incumbent to incorporate that in the stipulation.
I stand on what I said, Your Honors, but assuming arguendo that they were in for everything, I would also add that that is not enough. 3 open cases at trial is not enough to say that my client was unfit and that fitness failed on his ability to raise his children. The only evidence in the record of my client's parenting was that he was a very, very good father. And when he moved out because he was divorcing his wife, he stayed with those children and made sure they were okay. And DCF knew that he was pretty much the sole caretaker for at least the last 3 or 4 months because they knew that mother's mental health conditioning was rapidly declining. They did not file a CMP. And it needs to be pointed out as well that DCF did not offer or ask my client to do therapeutic services until 7 months after they removed the children and filed a care and protection. So I would argue DCF clearly was not concerned during the pendency of the case that father had these issues. They had many chances to ask for therapeutic services. They did a service plan in March of 16, did not put therapeutic services on it. And it wasn't, as I said, until 7 months after they removed the children that they did.
I have 2 other evidentiary questions for you.
Yes, ma'am.
One is with respect to the allegations of domestic violence. The carry, which was admitted into evidence, sets out the terms of the abuse prevention order. And may we take that together with the 51B to be evidence of domestic violence in the home?
No, Your Honor, there was a restraining order. Mother asked for 2, was declined 1, received 1. She received 1 7 days after father had called DCF and said, I'm very worried about her mental health. We don't know why she took it out. So Your Honor can definitely rely on the fact that there was 1 taken out, that it ended after 24 days. But we don't know why it was taken out. There's nothing in the record as to why.
May we draw an adverse inference from the fact that the father attempted to obscure the results of drug tests by blacking out certain tests and only allowing the department to see the negative test for heroin?
No, Your Honor, and the reason for that—
Or not may the trial judge have drawn an adverse inference.
Doing that, I believe, Your Honor, was the question. Thank you. No, the trial court did err, Your Honor, because the 51A, which I do need to point out was a non-identified reporter saying he suspected father used and sold heroin. That is the extent of the allegation.
Right, and that's not substantiated or proven in the 51B, but then it's followed by the refusal to undergo a DCF drug test or to provide an unredacted drug test to DCF.
Yes, Your Honor. And what also needs to be pointed out is father gave the heroin results after DCF said, you don't need to give us drug tests. You don't need to do this. But
they said you don't need to, but if you want to see your kids unsupervised, you have to. And then ultimately they said you have to, and he still didn't do it.
Yes and no, Your Honor. If I could clear up the timeline a little bit. The 51A was filed, I believe around December 15, and I'm sorry if I'm getting that wrong. DCF came to the house, said, you don't need to show us anything. Father said, no, I feel very strongly about this. He gave them a negative heroin test in December of 15 and in March of 16. Immediately after he gave them the second negative heroin test in March of 16, they wrote a service plan saying, well, now we want a full everything or you can't see your children. The problem with that, Your Honor, is that was an unreasonable request by the part of DCF. As Your Honor admitted, all they had was this unsubstantiated allegation that father took so to heart because he didn't do drugs. Or
but they also had the nurse who said he showed up in the emergency room high as a kite on the night that his wife incurred this fatal injury. So they have something.
We're jumping a year now, Your Honor. To address that concern, the nurse said he appeared high and he was acting strange. The police officer who also saw him that day said he was acting strange, but he didn't know that it was because of drugs. And mother told DCF twice that his stiff person syndrome, which is also very important to understand, could well be the cause of his appearance.
Well, but do they have to have probable cause, or do they have to, is the department, when they're put on notice that somebody who's already done a 10-year term for trafficking and is accused of dealing drugs again, are they not entitled to at least ask for a drug screen?
But they didn't, Your Honor. They only asked for the drug screen when he gave them the negative result. It was almost retaliatory at that point. They had no reason at that point. I see my time has expired. If I could just say very quickly, stiff person syndrome causes muscle rigidity, muscle spasms, and abnormal posture, which is looks like one who's under the influence of substances. I do see my time is up. Thank you for your leeway. I will rest on my brief.
Thank you. Who will be going first?
I will, Your Honor.
Okay.
May it please the court, Richard Salcedo for the Department of Children and Families. The trial judge in this case correctly concluded that father is unfit to assume parental responsibility for the two subject children, and that adoption of the children in accordance with the department's plan is in their best interest. In making this determination, the court considered 43 properly admitted exhibits and the testimony of 7 witnesses, including father. Based on this evidence, the court entered 248 findings of fact, none of which are specifically challenged on appeal, which when taken together, clearly and convincingly support its conclusions. Contrary to what father argues, there was evidence of his unfitness during the time he had the opportunity to parent the children. During that time, which was between 2011, the birth of their first child, and mother's suicide in 2017, there were a series of 51A reports filed citing concerns about possible drug use and concerns about domestic violence in the home.
If I could stop you there, one of the concerns that I have on this case is that there's a lot of accusations with all the innuendo that the accusations carry. But with respect to the domestic violence, we have the Carey report, but we don't have an application or an affidavit. With respect to the criminal records, we have pending cases, many cases that were dismissed. With respect to the drugs, we have the accusation of dealing, but that was never substantiated. How is a trial judge to weigh all this? And is it not possible to give a more refined evidentiary record to a motion judge who has these very critical and concerning allegations before him or her?
I believe the trial judge in this case looked at the totality of the evidence. Clearly, mother, according to the record, and had concerns about father that were expressed, especially during the last year of trial, last year of their marriage. She expressed being in fear of father. There was an allegation that he had harassed her at work and had slashed her tires.
On what basis is that admissible, since she couldn't be called? On what basis are her allegations of fear, her statements of fear, admissible evidence?
These were contained in the 51B investigation reports as conveyed to the department social workers.
Right. But they're
challenged in the record in this case, starting around finding 150, which detail mother's ongoing contacts, conversations with the department workers.
Was there any objection to the admission of that testimony?
No, Your Honor. And throughout this period, if the court, if this panel would review those findings, as well as the dictation, social work dictation, which was also admitted into the record, there was a very detailed contacts with mother throughout that last year, leading up to the time that she committed suicide in March. And throughout that period, the department was attempting to assist mother. Father, it should be noted, was really not in the picture at that time. Contrary to what was mentioned before, he was not primary caregiver for these children. He was missing for periods of time. Mother mentioned her concerns about his possible drug use during that time. She noted that he appeared spaced out and out of it, and she herself was insisting that he get tested, and on several occasions she made that request of him and he refused.
Could you address Father's counsel's argument that the admission of the criminal records is still subject to Frank's, and what that would mean, what firsthand knowledge means in that context?
I believe that the admissibility of those records is bearing on Father's unfitness. It's clearly, it was stipulated to and was part of the record. I think the court could give it the weight that it sought fit. I think in light of clearly the bulk of the criminal activity predated the birth of the children, but in light of Father's more recent criminal activity, I think the court could give it even more weight. I mean, Father was serving a prison sentence on an assault charge, and although a couple of the criminal charges have been dismissed, there were still several pending at the time of trial, and Father faced possible further incarceration at that time, which was proper to consider.
Under Frank, if the police officer arrives at the scene and says, witness A told me this, witness B told me this, defendant said this, is that all admissible or is that inadmissible because it's not based on the officer's firsthand knowledge?
I believe it is admissible, Your Honor, but I would have to.
I caught you a little off guard. I'm sorry. I didn't expect to hear Frank either, so I just thought I'd ask. Continue.
Okay.
Counsel, the judge found that the father was indicted on one of those charges, the assault with the dangerous weapon, and the father challenges that as clearly erroneous. Where in the record does it show he was indicted?
I would have to look in the record, Your Honor. I'm sorry.
Okay, that's all right.
I mean, if you find it and you want to file a 16L letter, let us, that would, just with the citation, that would be fine.
Okay. After the...
your time has expired.
Okay.
Well, Attorney Yanoff?
If my brother needs to say something, I would relinquish some of my time if he had something that he wanted to say to finish.
That's fine. I rest on my brief for my remaining arguments. Thank you.
Good morning, Your Honors. My name is Warren Yanoff, and I represent the children in this matter. Just to answer Justice Sullivan's, I believe that is in the evidence page 219 is I believe the reference to those, and that's probably on his query that was pending, just as a reference. The issue with the children is they are entitled to stability and permanency. We have a father who ostensibly says he wants to parent his children, and whether the department was, asking too much for drug tests, which doesn't seem appropriate. When he got a drug test, he was blocking out results, just checking for heroin. We have somebody who was really in non-compliance with his service plan. But more importantly, this is a person who was serving time at the time of trial for assaulting DCF workers. And you go past that, you can even go to the fact that his visitation was at best sporadic and argumentative and disruptive. So we're looking at a situation that a judge looking at this, knowing that there are 3 open cases regardless, and I referenced in my brief this court's case recently, adoption of Chet, in footnote 10, which allows a judge to consider the fact that there are pending cases. And the standard for, if you will, unfitness or best interest isn't necessarily exacting. And even if this person, even if the father were acquitted, there's nothing to suggest that that may be, that there were still actions that people could have testified to regarding those events. Just things get dismissed for a number of reasons, but the fact is that he, since spending 8 years in federal prison, there's a litany of charges that he's been arrested for. That is, I think, part of a background that the past, while maybe not totally predictive, but a judge can certainly rely on that as somehow prognostic.
Is that so certain? Many of those cases, I looked at the Carey, many of those cases were dismissed. Do we consider arrests that don't result in conviction to be predictive of anything in the absence of some testimony or admitted police report that describes what the underlying offenses actually were? I mean, I was concerned with the willingness in the briefs to just recite all of the arrests when the Carey shows that there were so many dismissals.
Well, I will speak to my brief. I indicated which cases were dismissed. I think the fact of the matter is it shows certain conduct in terms of being arrested, and whether a shoplifting was dismissed for a fine, there are different issues. I think we're talking about being able to provide permanency, and do we wait and, is this a situation where with 3 charges and given his criminal record, if he were convicted possibly on any of the future charges, are we looking at a year or 2? And that deprives the children of stability. But he's not even he's not doing what he needed to do, even to visit. He was disruptive. He was not willing to go to the visitation centers. He caused things relative to seeing his children. This is not a situation in which he's been compliant with the service plan. He's been forthcoming. And I think that it would have been the duty of his trial counsel, if these were issues, to actually exploit them and not stipulate to the admission of all that, that if they felt that there was facts that were relevant to saying this has nothing to do, but those weren't presented, Your Honor. They could have easily have called the police. They could have called other witnesses if these charges, other than the fact that they stipulated to allowing those in evidence without restriction.
Well, they stipulated to the police reports and they stipulated to the Carey, but that doesn't answer the question for me, what you do with the various components of the Carey. And fully, because the argument is that he's engaged in a pattern of disruptive behavior, and I fully understand your argument. I'm just trying to explore with you in the context of termination of parental rights, which have a constitutional foundation, how far we go.
And I think just on the issue of that he was in jail at the time of this trial for assaulting DCF workers, even though it was only a 3-month sentence, bears on his parenting. The fact, again, dealing with visitation issues affects his parent. There are, 14 factors, and visitation is one of them. His prior conduct, compliance with the service plan, regardless of whether that there was nothing brought up that during the pendency of before trial, that the service plan was inappropriate, he couldn't comply, it should have been that. There's nothing in the record indicating that except that he was not in compliance. And so I think that regardless of whether you address the issue of his criminal past, his actions, absent the criminal charges, show non-compliance. And in the past, and your case law says that non-compliance with the service plan can be grounds for terminating a parent's right. Lack of visitation can be a parent's right. And the fact that at the time of trial, he was incapable of caring for these children. So, and it is in their, and I just want to say, it's in their best interest that they be freed for adoption. And I see my time is up, unless there's any questions.
Thank you. Thank you all. That concludes the argument in this case. The case is submitted. We will take a brief recess now, and we'll resume the session at 11:20. Thank you.
Thank you.
And you'll enable the closed captioning. Yeah.
We are live and on the record.
Okay, our next case is case number 2019 P1678, Bridget O'Reilly versus Shaw's Supermarket Incorporated and others. You may begin.
Good morning, Your Honors. May it please the court. My name is Daniel Federico. I'm counsel for the appellant, Bridget O'Reilly. Ms. O'Reilly appeals from the lower court summary judgment of all counts of her employment discrimination complaint. She specifically requests the court to reverse and remand for trial on 3 counts of that complaint. 1, gender discrimination. 2, wrongful termination. 3, contract. Ms. O'Reilly specifically has omitted her age discrimination count and her hostile environment count from this appeal. Ms. O'Reilly asserts that there was sufficient evidence before the court as to direct discrimination concerning her gender. In a mixed motive type of case, if there's strong direct evidence that gender was a factor, then the burden switches to the defendant, and the defendant must prove an unbiased reason for the termination. In such cases, the question is typically one for the jury. And this is true from cases in Massachusetts. Wynn versus MCAD, for example, is cited specifically. Ms. O'Reilly
Counsel, before we get to whether or not this is a direct evidence case or a circumstantial evidence case, it would be a help to me if you could clarify what exactly you say the wrongful conduct is, rather than the evidence of wrongful conduct. Starting with, are you claiming that it's a separate actionable act of discrimination for her to have been placed in the director's role?
Yes.
All right.
Because there was evidence that was gleaned during the course of discovery, Your Honor, in which high-level management at Shaw's admitted under oath that the customer service area of Shaw's that role was exclusively for women only.
Well, I understand that as evidence of a discriminatory atmosphere or practices, some evidence of discrimination at Shaw's perhaps, but the deposition testimony I read said that that was offered to her as an option and that she could have stayed where she was. I don't see any claimed dispute of material fact as to whether or not the transition, the position was mandatory. And so I had some genuine confusion as to whether or not you were using that as a background practice or a separate claim of discrimination.
On in the joint appendix, page 74, line 19 of O'Reilly's deposition, she made it clear that she did not want the position of customer service director. She made it clear to Mr. Rinaldi, who was her immediate supervisor. She also made it clear to Mrs. Garnett, Cynthia Garnett, who was the vice president of human resources. She went into detail in her deposition that historically this was a role for women at Shaw's, right. That this was.
We understand that. So I don't want to eat up a lot of your time. So you're saying that this wasn't an option, it was an assignment.
It was an assignment. Okay. She voluntarily accepted it, but under reservations. And frankly, if she wanted to complain,
well, that's different. If she voluntarily accepted it under reservations, then you haven't created a dispute of fact as to whether or not it was a voluntary assignment.
Well, she accepted it. She didn't do it willingly or voluntarily. I misspoke. She accepted the position.
There's a difference between doing it involuntarily and doing it reluctantly.
Well, I guess that's a matter of fact for the jury in this case, because she was clear in her deposition, Your Honor, that she protested to the extent that she could. This is a 30-year employee who understands how this organization works. And I'm sure she felt that it was a risk, too substantial of a risk to deny this appointment. But there's evidence evidence in the record that she protested this, and she went to the level of the vice president of human resources and explained that this was something that she did not want to do.
Let's move on, because the clock is running. I take it you also claim that she should have been allowed to return as district manager when this position didn't work out. Is that?
I'm sorry, could you repeat that?
I take it that you also believe, you also have a separate claim that she should have been reinstated as district manager?
Yes, the demotion, which occurred in January of 2016, was unique in that Ms. O'Reilly testified that there were often special assignments within Shaw's, and that even as an example, Mr. Rinaldi, who was a very experienced Shaw's employee like Ms. O'Reilly, Mr. Rinaldi, a man, was placed in a special assignment and then moved back to district manager. And she cited this on several occasions, and she felt singled out because of her gender in that way, and not being able to be given the opportunity to go back to district manager.
Did she ever offer to return to work?
At what point? After her termination?
After her
no, she was, the court found significantly that in this case, Shaw's maintained all along that she could return to work up until the point of summary judgment in this case. The fact was found at trial, I'm sorry, at summary judgment, that in June, on June 8th of 2016, she was terminated.
Well, the letter says that you remain an employee of Shaw's. That was not my question. My question is there any evidence in the record that she offered to return to work?
At what point in time?
At any point.
At any point after she went out on her medical leave?
She did not.
Okay.
She was on medical leave and was being treated.
Okay. So thank you. Now I understand the framework.
So secondly, even under a pretextual analysis, and we think that there was strong evidence of an illegitimate motive concerning gender for the reasons stated in the brief, because of Shaw's policy exclusively hiring women for customer service roles. So therefore, the employer, in this case Shaw's, did not provide a legitimate motive that was free from genuine issues of material fact, and there are a number of facts that are listed in this complaint and in this brief. The pretext only analysis was flawed by the lower court because the court jumped to an assessment of Ms. O'Reilly's adequate performance at work prior to assessing whether she had been adequately performing at work before the January 29th, 2016 demotion meeting.
Attorney Federico, I'm sorry to interrupt, but I'm confused now because in answer to Justice Sullivan's question a short while ago, you cited the transfer into a gender identified position as the wrongful act, but now it seems as though for purposes of talking about pretext and proper basis, you're talking about the termination. And I realize that you have a separate claim for wrongful termination, but what is there separate from placing her in a, to use your term, gender-specific role? What is there about the termination that carries gender-based discriminatory attributes?
There are two parts to the allegations of discrimination. One was the placement in the gender role, and the second part was where the reasons for Ms. O'Reilly's demotion were not sufficiently supported by the facts, and there were a number of contradictory facts concerning the demotion in January of 2016.
So if I could try to understand, so the first adverse action you're alleging is the placement in the customer service position. And for
Yes.
that, you're saying that there's direct evidence of gender discrimination based on Shaw's history of only putting women in customer service roles. The second
Correct.
claim is that the demotion was also an adverse employment action. And for that, you're relying on the McDonnell-Douglas framework and saying that the reasons that Shaw's gave for that why she was demoted were pretextual. Do I have that right?
Yes, and how that links to gender is it relates back to the fact that she's in this women's only role. It's a very difficult policing kind of role that was developed by Mr. Rinaldi, where she's investigating stores and reporting on stores. That's exclusively for women. Men aren't allowed or required to be in that role.
Okay, but once she's in the role,
yes.
Shaw's demotes her because Shaw says she wasn't adequately performing the job.
Right, and that's where I think the court
reasons were pretext for gender discrimination.
Yes, and that's because we had shown that her 30-year performance evaluations were excellent. She had no issues up until the fall of 2015 when Mr. Rinaldi had placed her into the customer service role.
Right, but that predates when she was put in that role. So what was pretextual about the Shaw's reasons for why she wasn't adequately performing that role, the customer service role?
Because at the time, in January of 2016, Mr. Rinaldi alleged in his deposition and other pleadings that there were all these complaints about Ms. O'Reilly from several district managers. When probed as to the timing of those complaints, Shaw's failed the burden of persuasion. They certainly failed the burden of production as to when individuals complained. Our allegation is that those complaints are pretextual as a basis for her termination and her demotion, because they occurred probably in February of 2016, and that's based on the testimony of Ms. Garnett, who was the vice president of human resources. So they went back and tried to use these complaints, which were really not about Ms. O'Reilly, they were about the process. But nonetheless, they used these complaints, which occurred after the termination. If you look at the description of the January 29th meeting, Mr. Rinaldi had very little reason for terminating Ms. O'Reilly. And furthermore, Ms. O'Reilly was entitled to oral and written warnings according to the Shaw's termination policy. That was completely ignored. She was completely blindsided on January 29th. So for all those reasons, even under a pretextual analysis, if the court agrees with the lower court.
Wasn't there some evidence, though, that they just decided to get rid of this position at a director level, that they just didn't think it worked, and therefore she was out of job?
There was, but again, that was not discussed prior to January 29th. That was reasons after the lawsuit was filed. And our allegation is that Mr. Rinaldi and others went back and then reassessed the program. But at the crucial moment of her demotion, that was not an issue. There was no discussion of changing the program. There was a strategy meeting. Strike that. Mr. Rinaldi presented the January 29th termination meeting with Ms. O'Reilly as a strategy meeting. And there was some discussion about changing the process of evaluating the stores to increase the customer score indexes. But that really wasn't the reason for the meeting. Ms. O'Reilly.
I see that your time has come to an end. You can rest on your brief for what remains.
Thank you.
Thank you. Mr. Shank.
Good morning, Your Honors. May it please the court. Jonathan Shank for the appellee, Shaw Supermarkets Incorporated. Your Honors, the sound decision of the trial court granting summary judgment to Shaw should be affirmed in its entirety. The evidence in this case reveals that Ms. O'Reilly was demoted from her job as Director of Customer Satisfaction after 5 months because she was not performing at an acceptable level. She also failed to improve the customer satisfaction scores, which were of paramount importance to the company. It's undisputed that 1 month prior to her demotion, Ms. O'Reilly offered to step down after she was informed that her actions had resulted in distrust from the managers whom she was there to support. It's also undisputed that shortly after she offered to step down, she engaged in an inappropriate, unauthorized meeting, which resulted in a female store manager crying hysterically and reporting to the vice president of human resources that it was the worst that she'd ever been treated during her lengthy employment with the company. It's also undisputed that 3 days before her demotion, Ms. O'Reilly conceded that the customer satisfaction program was not working, that she had not gained the trust of the district managers, and she suggested that Shaw should drop the program. Against this backdrop, Shaw's rationale for its decision is obvious. On appeal, Ms. O'Reilly has abandoned her claims of age discrimination and hostile work environment. Instead, she alleged that Shaw has engaged in sex stereotyping when it offered her the Director of Customer Satisfaction role. She also contends that Shaw's engaged in gender discrimination by demoting her, or that she was somehow a whistleblower by merely performing her job duties. These arguments lack any merit, and despite the more than 3,000 pages of documents in the appendix that Ms. O'Reilly submitted, there's no evidence, there's absolutely no evidence to support these claims. There's no evidence of gender discrimination. There's no evidence of sex stereotyping. There's no evidence of a retaliatory termination. While Ms. O'Reilly may disagree with Shaw's decision, or she may be disappointed with Shaw's decision, think it's unfair, that subjective disagreement or disappointment is insufficient to meet her burden of proof of establishing pretext or withstanding Shaw's well-founded motion for summary judgment. With respect to Ms. O'Reilly's sex stereotyping claim, it can be easily disposed of. As the trial court recognized, and as Your Honor's questions demonstrate, this voluntary lateral position, which Ms. O'Reilly accepted, was not an adverse employment action by her employer, and it therefore cannot support a claim of discrimination under Chapter 151B. This position was incredibly important given the directive from Shaw's and frankly throughout Albertsons that Shaw's needed to improve its customer satisfaction scores. It presented a tremendous opportunity for Ms. O'Reilly. She could have declined this position and remained a district manager. Instead, she chose to accept the position, and she cannot now transform that voluntary decision into an adverse employment action. The case is...
Can you tell us where in the record it shows that there's no dispute of fact as to whether she could decline the position?
I would have to look. I don't have that site offhand, Your Honor. I think it's in our briefs.
Well, one of the difficulties for us in reviewing this case is that the statements of undisputed fact are do not end up addressing a lot of the issues that are argued, the factual basis of a lot of the issues that are argued. And so even though we have an anti-ferreting rule, it requires us to do, if we want to, a lot of parsing of the record in order to determine which facts are disputed and which aren't.
Your Honor, respectfully, I think all the citations in our brief are supported by the appendix. I know there's some parts where
you have put in record cites, but normally we would go to the statement of disputed and undisputed facts, and perhaps it's there. I mean, there was a lot of material here. It's just that this has been a difficult case, at least for me, to get my arms around.
Understood, Your Honor. Yeah, I mean, this was not, I think Your Honor's question was aimed at, there's cases where there's a unilateral transfer by an employer where it says, okay, you're now doing this job and we're moving you to this job. That's not what happened here. There's no evidence in the record to support that. And also, I think it's important to note that the case is readily distinguishable from the sex stereotyping cases that Ms. O'Reilly relies on. For example, the Price Waterhouse decision. In that case, an employer refused to make the plaintiff employee a partner in the firm because of gender biases and sex stereotypes. That's not what happened here. She was offered this position. She accepted this position. And frankly, everyone at Shaw's wanted her to succeed because it was very important to the company. I also want to briefly address, my brother made a comment during the argument and in the brief, I think that there was testimony that this was a position for, quote, women only. There's no such testimony about that. Shaw's, the director of customer satisfaction role, Ms. O'Reilly was the first person to ever hold this position in the company. The fact that women held customer service roles at Shaw's is not direct evidence, as Your Honors are aware, of some type of discriminatory animus or sex stereotyping. With respect to her demotion from the customer satisfaction role, this claim fails as well because, as the trial court articulated, there was ample evidence in the record that Ms. O'Reilly was not performing her job at an acceptable level, which is required for a prima facie case of discrimination. Additionally, there's no evidence of pretext. After Mr. Rinaldi, the company's vice president of retail operations, told Ms. O'Reilly in 2015, December of 2015, that she had to regain trust from the district managers, she engaged in this incredibly inappropriate interaction with a store manager 1 month later. As a result, Mr. Rinaldi decided that she should be removed from this position. Ms. O'Reilly has no evidence that this was pretext. In fact, 3 days before the demotion, she emailed Mr. Rinaldi, confirmed that there was still distrust, that the program wasn't working, and told him that they should drop the program entirely. In addition to her acknowledgement regarding the validity of Shaw's legitimate, non-discriminatory reasons for the demotion, there's ample evidence in the record that belies any claim of gender discrimination here. First, Mr. Rinaldi appointed Ms. O'Reilly to the Director of Customer Satisfaction role in December 2015 with full knowledge of her gender. He demoted her from that same role 5 months later. As the case law makes clear, given that he was the individual who made the decision to appoint Ms. O'Reilly to this position, this important position for the company, and he's the same individual that made the decision to take her out of that role in a short time frame, that undercuts any inference that his decision-making was motivated by some type of animus against her because of her gender. Second, he decided to demote Ms. O'Reilly after receiving complaints from female members of management at Shaw's, the store manager, the district manager, the vice president of human resources. Again, this undercuts any type of inference that Mr. Rinaldi was motivated by a discriminatory animus against women or a gender bias against Ms. O'Reilly. Finally, he promoted a female employee to run the customer service department after Ms. O'Reilly was demoted. Turning to Ms. O'Reilly's wrongful termination claim, wrongful termination and violation of public policy claim, which is identified in the complaint.
Before you get there, there is another component to the claim, which is, I think, which is that even if taking her out of the customer service role was not discriminatory, even if the summary judgment was granted on that component of it, the failure to have her return to her position as district manager is a separate and independent act of discrimination, relying on comparator evidence with male employees. Could you address that?
Yes, Your Honor. There's no, first of all, there's no comparator employees because there's no employee that held this position before, this Director of Customer Satisfaction position. Ms. O'Reilly was the only one to hold that role. So the record doesn't support.
I think in Trustees of Health and Hospitals versus MCAD, the SJC established that you don't have to have a perfect one-to-one correlation. And the plaintiff did put in some evidence that men had been allowed to return to their old jobs. And as you know, on summary judgment, you carry the burden on all issues, even if you wouldn't carry the burden at trial. So how do we parse that out?
Yes, Your Honor. So first, the position was filled. There was not an open district manager position. After she was moved from district manager in Vermont, they filled that role. So there was not an open position to put her in. But secondly, and I think more importantly, while she was working in the Director of Customer Satisfaction position, she engaged in this inappropriate behavior. She was this meeting that we talked about with the Canton store and other acts that made Shaw's determined that she was not qualified or should not return to that role. They had severe questions about her ability to manage people. Her actions created distrust, and those are not the type of components and qualities that you want to have in someone who's a district manager. So if nothing happened in the interim, I suppose I could see that, but she engaged in subsequent conduct after she was taken out of that district manager role, in addition to the fact that there was not an open position, that made Shaw's determined that it was not appropriate to return her to that leadership management type position.
Is there any evidence in the record that the comparators that she referred to had their positions held open while on special assignment and that those cases were therefore different?
I don't believe there's evidence in the record that those positions were held open. I also don't believe there's any evidence in the record that those alleged comparators engaged in the type of misconduct and inappropriate behavior while they were in these special assignments.
Right. The record's just kind of silent on the comparators. Okay. If they are comparators, and I take your point.
Thank you, Your Honor. Turning to the wrongful termination claim, Your Honors, the grant of summary judgment should be affirmed for a number of independent and compelling reasons. First, Ms. O'Reilly was never terminated. The record is clear that she was demoted and
wasn't being paid, right?
She was not being paid after she went on a medical leave of absence. After she was demoted, she was moved to a store manager position and she was being paid during that time. After she said, "I cannot work," she was not continued to be paid while she was out on a medical leave of absence. That's correct, Your Honor.
What's the difference between being terminated and not getting paid?
I think a termination is when an employer says you no longer work for this company anymore. A leave of absence, when you're not working, it's incredibly common that you're not being paid when you're on a lengthy leave of absence, as Ms. O'Reilly was. And I think it's important to note there was no actual termination, and the wrongful termination doctrine can apply in cases where you have a constructive discharge. As your honors are aware, that requires someone to resign because the employer made the workforce or workplace so intolerable that there was no choice but to resign from employment. That's not what happened here. There's no evidence in the record that Ms. O'Reilly ever resigned from her employment.
Well, the judge found, and understanding our review is de novo, but the judge found that there is a genuine issue here because when she exhausted her medical leave, Shaw's notified her that it was permanently filling her position and then discontinued her benefits, cut off her cell phone, her email, etc. So why is that wrong?
I don't want to say it was wrong. I think it's wrong to suggest, as my brother did, that the judge found that Ms. O'Reilly was terminated. That's certainly not what the judge found. The judge found that there could be a dispute on whether she was terminated or not and moved on to the other issues addressing the flaws in the wrongful termination.
Well, understood that the judge did not dispositively conclude that she was, in fact, constructively terminated. The judge found that at least there was a triable question on that. And for purposes of where we are here, why is that an argument that you're continuing to press?
Because as your honors noted, it's a de novo review. To have a constructive discharge, constructive termination, there's got to be evidence that the employee resigned from employment. If the employee goes on a leave of absence and continues on that leave of absence, there's no case law that would support that would be a constructive discharge. They have to resign from employment, and that never happened here, and there's no evidence in the record to support that. But moving on to the other arguments with respect to the wrongful termination claim, Ms. O'Reilly never.
If I may, just to be clear in the record, there was no retaliation claim filed at the MCAD or in the Superior Court, and there was no disability discrimination claim filed at the MCAD or the Superior Court, correct?
That's correct, Your Honor.
Thank you. Keep going.
With respect to the whistleblowing aspect of the wrongful termination claim, Ms. O'Reilly's job as Director of Customer Satisfaction explicitly required that she report out-of-code food as part of the company's mandate to improve its customer satisfaction scores. To be a whistleblower, an employee has to step outside of his or her shoes from the job that she's performing and take some type of action that's adverse to the employment. Far from acting adverse to Shaw's, Ms. O'Reilly was merely performing the duties expected her and the duties that were assigned to her in this role. As the trial court noted, she never stepped outside of her role as Director of Customer Satisfaction. To the extent that she identified issues in those Code Blue reports, they were characterized as relating to Shaw's policies regarding food quality, freshness, with the ultimate goal of improving customer satisfaction. In her brief, Ms. O'Reilly cites to federal and state food codes and regulations regarding food code, but there's no evidence in the record that she ever invoked these statutory provisions or regulations during her employment. And the case law is clear that simply performing one's job duties is insufficient to become a whistleblower for purposes of a wrongful termination claim.
Thank you, Mr. Shank.
Thank you, Your Honor.
That concludes the argument in this case, and the case is submitted. We will move next to the final case on our list for hearing today.
Thank you.
Thank you, Your Honor.
We are live and on the record.
That brings us to our last case on the list for hearing this morning, case number 2019 P1828, Robert Taverna and another versus KARLA Taverna and another. You may begin.
Your Honor. May it please the court, Allison Walsh for the appellants Robert and Sally Taverna, appealing the dismissal of their petition for grandparent visitation by the Barnstable Probate and Family Court. This case presents the latest in a line of cases that posit whether the trial court has erred in dismissing a grandparent's petition for grandparent visitation under Rule 12b-6. We come before you today to argue that the court did err in this case, specifically as the facts of this case differ from those of the cases that have previously been decided by this court and others. In the past 2 years, this court has had the opportunity to address this issue several times and has found that dismissals were appropriate in instances in which, for example, the grandmother had not formed a significant relationship with her baby grandchild, or as last year, when the court found that grandparents who had petitioned for visitation had a sort of standard or traditional grandparent relationship with their grandchildren, which involved doing activities with the grandchildren, taking them on vacation, spending holidays with them, and things like that. The court in that case found that that type of relationship did not meet the requisite significant harm standard that is required in these types of cases. I would submit that our case is different insofar as the grandparents in this case, my clients, the Tavernas, had the opportunity for the first 4 years of their granddaughter's life to live with her. My client's daughter was divorced when their grandchild was approximately 7 months old, and at that time, the grandchild began living with them in their home. She lived with them for approximately the next 4 years. At the time that this matter came before the trial court, the child was 10 years old. And at that time, she had lived with them for the first 4 years of her life, had then maintained a strong relationship with them for the next several years, returned to their home for a short period of time in or around 2018, I believe. And then subsequent to that, things deteriorated within the family.
Right, but why isn't the relationship for the 6 years preceding trial akin to the relationship at issue in Frazier?
Your Honor, I would say that the relationship is different because the Fraziers never had the child living in their home for those tender years. This child began living with my clients when she was 7 months old. She was an infant and spent her formative years with them.
Okay, but surely the passage of time is relevant to the inquiry. Would you agree with that?
I would agree to an extent, but at the same time, I think the question then arises if we have this situation where a de facto parent relationship or a quasi de facto parent relationship, a relationship of close bonding, to use some of the terms that the prior court opinions have used, has been formed. When does that end? If there is a bond that has been formed at any point in a child's life, especially a bond that forms so early in a child's life, doesn't that bond continue? And who is it to say, especially at a 12B6 motion, that bond doesn't exist, such that we should make it to the next level?
The question isn't whether there was a pre-existing relationship at any point in time. The question is whether there's a significant enough relationship that disrupting it is going to cause the child significant harm. And it seems to me when you have a 6-year passage of time, where the relationship is more of the traditional sort that you see between grandparents and children, it's really hard to say that overcomes the very strong presumption that the parent is acting in the best interests of her child.
Well, I would say to that, Judge, that at a 12B6 hearing, the inferences have to be interpreted in favor of my clients who are petitioning. And if they're putting forward a case, which they did, that they in fact had this strong relationship, which was, the strongest that there could be in terms of the fact that the child lived with them for the first half of her life.
It's a heightened standard under Blix. And it seems to me the implication of what you're saying is any time there's a pre-existing relationship, even if it's since been severed or, the relationship the child is no longer living with the grandparents, that you get past the 12B6. And that can't be right given what the court said in Blix.
If that's what I would say, Judge, the court in Blix, I believe, actually contemplated situations just like this. The court in Blix actually referred to the fact that single parents in America are much more likely to live with their parents and to have their parents, the grandparents, involved in the children's lives. And so when they say that, even if it's in dicta, I would suggest, Judge, that Blix is actually contemplating the exact sort of situation we had, where a single mom moved back in with her parents, relied on them for support, raising her child until she sort of got on her feet and was able to move on. But that child's bond is still so strong with those grandparents from those first few years that it's hard to say without an expert, really, that bond's been severed.
My question goes more to what the Blix court said about burdens and the procedure in these cases, because Blix said that just the fact of litigation, full litigation, can impede on a parent's constitutional rights to make decisions for the benefit of their children. And that's why Blixt imposes a heightened pleading standard on the grandparents. So it seems to me it can't be that a grandparent can come in and clear that 12b6 hurdle simply by alleging that at some point in the past, there was a relationship that might be characterized as a de facto parent-child relationship. There has to be something more. And here there's been a 6-year passage of time. So where do you draw that line?
So I think the line is difficult to draw, Your Honor, in the sense of these are families, right? So when an adult child and the grandchild are living in the home and they move out of the home, and suddenly, the grandparents are seeing the children less. The grandparents probably aren't happy about that, but maybe they try to work that out with the adult child, as families do. And at some point something goes south, and now we're looking at court intervention. If there's going to be any lag of time that is going to, let's say, be punitive towards the grandparents, it's inuring towards not having families try to work things out, right?
It's not a question of punitive toward the grandparents. The question, all of these things are looking at the best interests of the child and the need to preserve the bonds that are essential for the child's development. And just going back to Judge Shin's observation, what we have here is read in favor of the grandparents on their showing, a demonstration that there was in fact a rather substantial bond for a period of about 3 years, but that was more than 6 years ago, and a substantial portion of the child's life the child lived in the absence of that de facto parenting framework.
Judge, could you just repeat the question? I'm sorry, I didn't.
Well, my point is that that it's not simply a period of time, but the fact that for the vast majority of the child's life, the bond on which you are relying has not been a part of the child's daily existence, right?
I think my point, Judge, is that we don't know that bond ended. We're assuming that bond ended, but who's to say that without having expert bonding testimony?
How can it be there when the child is not seeing the grandparents except sporadically over that 6-year span?
Even if the child's only seeing the grandparents sporadically, a bond that was created with the grandchild and the grandparents at that young age could potentially be strong. It is stronger than the type of bond that would be between grandparents who only saw the children at Christmas or on vacations. This is still a different case than prior ones that have been considered.
It would be stronger than grandparents who never had that constant interaction. However, that's not, as I understand it, what Blixt is looking for. It has to be a present relationship that is such that the child's development would be damaged if that is disrupted. And I mean, not to put too fine a point on it, but it has been disrupted for the last 6 years. Right?
They certainly have not. They have not lived with the child except for 3 months, I believe, in 2018 in the last 6 years.
Right. And so to suggest that they must be allowed to restore that relationship when it hasn't been in place for more than 6 years is a heavy lift.
Well, they're certainly not asking to restore the type of relationship they had when they were younger, when the child was younger. They're simply looking to just maintain some sort of contact with the child.
I understand.
Should I continue?
Please.
One thing that I believe is important when considering all these standards that were just raised is when we're talking about the de facto parent concept. I am unaware of any cases which say that a de facto parent status can suddenly end. There are cases that point to the fact that a de facto parent status is created with at least 2 years minimum time with the child living with those de facto parents. But there are no cases that I am aware of that say that there's a point at which a de facto parent relationship suddenly ends. So if you are once a de facto parent or somebody close to a de facto parent, to my knowledge, there is no law so far that has ever said that that de facto parent relationship can suddenly end and shouldn't then continue in the eyes of the law on behalf of the child. And I think that is an important piece of this case, given the timing. Your Honor, I think we've actually addressed all of the other standards already that I was planning on arguing. I'm happy to rest on my brief for the rest of my time, unless people have further questions.
Seeing none, thank you for your argument.
Should I begin?
For the appellee.
Thank you. Chief Justice Green, Justices Sullivan and Shin. May it please the court, my name is Attorney Barbara Liftman, and I represent KARLA DeStefano, formerly known as KARLA TAVERNA. KARLA is the mother of Arden Farrington. Your Honors, the courts of the Commonwealth cannot and should not be used to supplant the decisions of otherwise fit parents to determine what persons and influences their children should and should not be exposed to. Likewise, well-reasoned decisions of the lower court judges consistent with applicable law should not be overturned on appeal. There is no evidence whatsoever in this record to suggest that Arden Farrington is anything other than a happy, healthy, and well-adjusted child. There's no evidence whatsoever in this record to suggest that KARLA DeStefano is anything other than a fit parent. It takes the utmost arrogance for these grandparents to suggest without any evidence that the child will suffer significant harm simply by virtue of being deprived of a relationship with them. The fact that the child lived in their home and the grandparents helped to care for her several years ago does not elevate this case to one where significant harm can be inferred simply by terminating or eliminating the relationship. In an ideal world, children would have healthy relationships with both parents and all four grandparents, and each of these relationships would be a positive influence on the child's development. But we don't live in an ideal world, and reality dictates that not all adults, by virtue of a blood relationship, enhance a child's life, and a good parent determines what relationships benefit the child and which ones do not, and acts accordingly. If a child suffers significant harm or is in significant danger by the actions of a parent in limiting contact or relationships, there are mechanisms in place to safeguard the child's welfare, including intervention by DCF or guardianship proceeding. And I suggest that this case would have turned out very differently if the grandparents had brought it when the child was 4 years old. Nowhere in the record of this case is there a shred of evidence that this child suffers or is in danger of suffering significant harm by not seeing her maternal grandparents. Fit parents should not be forced to spend money on legal fees to defend their decisions as to what is and is not in their child's best interest simply because of hurt feelings. The lower court correctly applied the legal standard and upheld KARLA DeStefano's constitutional right to decide whether and when and under what circumstances her daughter should have a relationship with her parents. And I implore this court to affirm that decision. I would be happy to answer questions or to rest on my brief if there are none.
Seeing none, I thank you both. The case is submitted. That will conclude the argument session today.
Thank you, Your Honors.